Hello everyone. I've decided today to do a webinar about confidence in the courtroom for the SQE2 candidates. That is because most of SQE2 candidates fear advocacy the most. Out of all the 16 assessments, advocacy is the most feared. And why is that? It's because we are not used to pleading before a court, and it is the first time for many of the candidates. So many will believe that they need a natural talent at speaking eloquently and thinking on their feet in order to perform well. Or they might also, or as well, need to be born with a gift, which is not the case. So my goal today is to prove you that you do not need to be born with a gift. All you need is a strict and specific methodology that you should apply religiously to all your court submissions in order to perform well in advocacy. And that's all you need, along with knowing the law, of course. So, before we start, I just want to let you know that in addition to this webinar, I have also prepared an advocacy guide that you can download on FQPS Academy's website. So feel free to do so. It is going to be useful for your preparation, and it also contains a few extra resources that I might not mention today during this webinar. Alright, so let me give you a brief overview of what exactly we're going to discuss today. First of all, I'm going to explore with you what exactly you need to do before even trying to make submissions before a court. So what you need to do at home in your own time. Then we are going to explore the 9-step submission structure. Then we are going to see what exactly the judge will be expecting from you on the assessment day. And then finally, we are going to conclude with some advocacy practice. I have prepared for you a list of courtroom phrases that you can use and reuse in any court application. And that is going to help you get used to the court language, court etiquette that you might not be familiar with yet. Alright, let's begin with how to prepare for advocacy. There are 4 important tasks, 4 important homework you must complete before even trying to make your first attempt at advocacy. So what are they? First, and it might not be a surprise, you must know the law. You must know criminal law, criminal proceedings, you must know contract law, you must know tort and civil proceedings in order to be able to make submissions before a civil court or a criminal court. So that's quite common sense, and the better you know the law, the more natural it will feel to make submissions before a court, and you will ultimately feel more confident. Alright, so the second homework that you must complete is thoroughly understanding and learning the submission structure. We will see later on that there are 9 steps which should always be included in any advocacy, pleading, or submission. So we will dive deeper into these 9 steps so that on the exam day, you know exactly what you should do from the moment you enter the assessment room. Now, the third homework you should do before trying to make your first attempt at advocacy is getting used to the SRE criteria. I know this step sounds quite boring, to be honest. It's not very interesting to read the evaluation grid. I agree with you. So what we're going to do is a little more than that, than simply read what the assessor is expecting from you. What we will do is explore what it implies for you in practice and see what it means for you in terms of behavior and language and knowledge in general. So we will dive a little deeper into the assessor criteria, and I'll also give you tips in order to perform better on the advocacy assessment day. And finally, what I believe you should do before attending at your first pleadings is getting used to some court language. So I will be providing you with a list of sentences, courtroom sentences that you can use in any court application. So that will help you knowing exactly how to introduce yourself, how to introduce your case, how to introduce the facts in your case, or how to make a legal argument in which order. This is very important. How to even conclude your submission, or simply how to reply to a judge. For example, what do you say when a judge say thank you? You do not say no worries, or you do not say welcome. That's not courtroom language. So what I'm going to do is give you a list of sentences that you can learn by heart in order to be efficient on the exam day. And do not be worried about courtroom language too much either, because if you learn these sentences, you should be ready to plead. There aren't 100 sentences to know. There are maximum 20 sentences. So just learn them and you should be ready to gain the famous courtroom language. So without further ado, let's start with the 9 steps submission structure. Here they are. So there are 9 steps that you should not miss. You should not miss any of these steps on your exam day. Advocacy is mainly about structure, okay? So if you know the structure, you know 50% of what we expect from you. So the first step is to address the court properly. Depending on the nature of the judge or the court, you'll see that in the guide there is a link forwarding you to the SRO website, which will explain in detail which word term you should use in order to address which particular judge. So I invite you to check that link and learn by heart whether you should say judge or your honor. But remember that we do not address the court by saying sir or madam anymore. This is outdated. We say judge instead. Second, you should introduce yourself clearly by simply stating your full name. And then third, you should also introduce your party. So if it's before a civil judge, just mention whether it is a money-only claim or an injury claim, and if it's a criminal proceeding, then mention the exact offense that the defendant has been charged with. So that's quite easy, isn't it? The first 3 steps. If you are unsure about how to do it, how to address the court, introduce yourself, introduce your party, do not worry, because as I've mentioned, we will be discussing or discovering common courtroom phrases that you can use, which include as well these steps. Alright, so the 4th step now is to clearly state the nature of your application. And ideally, you should also provide the legal ground for your action. So if it's bail application, or I don't know, maybe setting aside a default judgment, try to learn by heart the legal ground, because although it's not mandatory, it does give a good first impression to the judge, and first impression is very important. Know that the judge will be paying very close attention to your first word, and that will set the tone for your entire presentation. And it is easier to maintain a good positive impression throughout your submissions rather than trying to correct a negative impression. So be careful how you address the judge, because the judge can be offended by not being addressed properly, and then they might stay in an offensive position throughout your submissions, or it might take them some time to realize that you're actually good at making legal arguments. We want to avoid first negative impressions, right? So let's explore the next steps. We have number 5, bundle of documents. Ensure that the judge has the relevant bundle of document. This is quite easy to do. It's just one sentence. You just say, Judge, you should have before you a bundle of documents including so, so, and so, which I will be referring to throughout my submissions. And the judge will answer by saying, I do, thank you. To which you should reply, I am most grateful, and then continue with your submissions. And the 6th step is providing a summary of the facts. So at this stage, you do not need to give a detailed summary of the facts, because when you will make your legal points, your legal arguments, that will be the moment to provide specific facts, okay? So for now, you do not need to give too much detail, just an overview of your case, just so that the judge knows what you will be talking about, just to provide a context, not too much detail. All right, so you did the 6th first step, which are addressing the court properly, introducing yourself, introducing your party, stating the nature of your application, ensuring the judge has the bundle of documents in their possession, and providing a summary of the facts. And that is when the heart of your submissions, of your pleading, begin. From step 7, you will start pleading for your client interest, pleading for their case. But do not overlook the first 6 steps. Do not neglect them, because even with very strong legal argument, if you skip the first 6 steps, the judge might still find you average, because they are expecting from you an introduction, a middle part, and a conclusion. And everything is equally important. So see the first 6 steps as very easy marks to gain, okay? So it's very easy. You just have to address the court, say your name, present the parties, a brief summary of the facts, etc., etc. All right, so step 7, state the legal issue raised specifically. You can do so by saying, Judge, the legal issue raised in this case is, for example, whether or not the defendant actually consented to the contract made on April 7, 2023. And now the judge knows what you will try to do. Alright, so you did state the legal issue raised expressly. Now, step 8. Provide the legal test for your court application. You can do so by saying, for example, as I'm sure the court is aware, the legal test for, and then you provide your legal test. Most of the legal tests for any court application will be separated into several specific conditions that must be met in order for the judge to grant your request. Most of them have 2 or 3 conditions that must be met. These conditions, that are referred to as limbs, will constitute your separate submissions. So if your legal test has 3 conditions, you will make 3 submissions before the court. And then for each submission, you will make a legal argument, a legal point. You'll try to prove your point to the judge. So for each limb, there is a specific way you should follow in order to make your point. And that is, first, by stating the legal rule, so that's the condition, providing the facts that are relevant to that legal rule specifically. So you can be very specific about the facts here. You can provide dates, names, specific sentences that you found in your bundle of documents. And it is very important that you cross-reference, that you quote, expressly quote, certain sentences, short or medium length, from the bundle of document. You must draw the court's attention to specific facts that are included in the bundle of document as evidence to back up your argument. You can do so by saying, if I may refer the court to page 9 of Mr. Smith's witness statement of the bundle of documents, and I quote, and then you quote. And once you have provided the legal rule, you have provided the facts and quoted the bundle of documents, the last and final step will be to apply the legal rule to those specific facts in order to draw a logical conclusion. So for example, if your legal rule is, let's say, all contracts made under duress are voidable, then the facts will be client A was forced to sign the contract by business B, and then your conclusion will be the contract made between client A and business B is voidable. So you apply specifically your rule to the facts that you have provided to the judge. And that's how you should always make a legal point. There is no better way than that, and it is actually called syllogism. We will be speaking about syllogism later on during this webinar. But know that you must follow these steps: legal rules, facts, conclusion. Each time you want to make a legal point, do not switch the order. Do not start with facts and then give your legal rule and then conclude, or do not start with the outcome you are hoping for and then provide some facts and then some legal rule. This is going to sound messy, and if you want to look confident and be effective, you must follow these steps. All right, and so let's say you are done. Use your first limb. You have provided the legal rules, the facts, and the conclusion. Then you transition to your second limb. It is very important to transition into signpost. The judge will be actually expecting you to do so. And remember that by doing so, you're just making the judge's life easier. It's easier to follow along with your submissions if you make it clear. If you make it clear what you're doing exactly. So once you're done with limb 1, you say, I will now turn to my second submission, namely, and then you give the condition or your second submission. Then again, you should follow the exact order that we've mentioned. Legal rule, facts, conclusion. Legal rule, facts, cross-reference, and then to conclude, legal rule applied to the facts to draw a logical conclusion. And that's when you are done with the core of your submissions. You have introduced yourself and your case properly. You have introduced the legal issue properly. You have made your legal arguments. It's now time to conclude. So your conclusion will be divided into 2 parts. The first one, and it is very important, many students forget to do so, you must make an express request to the judge. The judge cannot grant your request that you did not make. Even with the best legal arguments, with the best evidence to back up your arguments, if you do not make a request to the judge, you are going to lose marks. It is not up to the judge to draw the conclusion and know what outcome you're looking for. So what you must do is state expressly what you're looking for, what you're hoping for the judge to order, a brief reason why you're hoping for it. And then it's good. Then you have your first part of your conclusion. For example, you could say, for the reason mentioned above, Judge, it is my submission that the default judgment made on 7 April 2023 should be set aside. And voila. Okay. So you did the first part of your conclusion. The second part is to let the judge know that you have finished your conclusions. And how do you do so? It's very easy. You just say, unless I can further assist the court, this conclude my submissions. It's a very easy sentence. But if you forget it, then there might be an awkward silent moment. A silent moment where you will be looking into your judge's eyes and the judge will be looking into your eyes until the judges decide to speak up and ask you whether or not you are done with your submissions. You do not want to force the judge to speak, because the only time the judge should speak is when they have, and if they have, a question about the case. Right. They should not speak for your lack of communication. All right. Great. So we now have explored all 9 steps that will be expected from you on the exam day. A simple reminder that is very important to transition, right? Transition between your legal points, between step 8 to your first limb, and from your first limb to your limb 2. Don't forget to transition. All right, so now that we have explored the 9 steps for a good pleading, let's explore what we expect from you on the exam day, and that is what are exactly the criteria that the SRA created in order to assess you properly. All the assessors, the judges, will be given an evaluation grid, a similar evaluation grid, and you must know what's in it in order to tick all the boxes. But you must also understand what it implies in practice. So that's what we are going to explore now. So the first criteria is about using appropriate language and behavior. The first one that happens at the very first second you address the judge is actually how you address the judge, by saying either "you honor" or "judge." Do not switch it up. Your very first words will be crucial to set the tone for your entire presentation. So that's the first language appropriate behavior that you must keep in mind. Then there is the sitting protocol. In civil proceedings, you must make your submission seated, and in criminal, you must stand up and stay so throughout your submissions. Then another point about language and appropriate language is how you refer to the parties. So in civil, you could say the claimant, the defendant, the claimant or the defendant. And in criminal proceedings, you can say the prosecution, the defendant, or the prosecution and Mr. Smith, that is the defendant's name. Do not use names for civil proceedings. Stick to the claimant, the defendant, or the respondent. Whereas in criminal proceedings, it's actually better to use the defendant's name because it does add a human touch. So, civil proceedings, not use name. Criminal, better to use the defendant's name. Once you have decided how to refer to your parties, how you're gonna call them throughout your submissions, stick with it. Do not switch up to another way of referring to them, because this is going to confuse your judge and you will lose mark for doing so. So just practice by choosing a way to refer to your parties and stick with it. That's the easier way. We have also body language. That is an important point. Body language, well, we often move our head or shoulders or hands, and during your submissions, it is better to try to stay still. Although, if you move just a little like that, it's fine, but if you have more expressive movements, that might be a problem, and it will undermine your submissions. One way that is not very pleasant is to record yourself and watch the footage back in order to spot any movements you might do unnecessarily, and that might take away from your presentation. So I would highly advise to do so, but I know it's kind of awkward to record yourself and then watch it. So feel free to try it and see if you have any hands, shoulders, head movements that are a little distracting from your submissions. Alright, professionalism. So why is the first criteria about behavior? Remember that your client is relying on you. They are trusting you with their case, so they should expect at any time that you act professionally. And also, it is an SRA ethical principle to uphold the public trust on the solicitor's profession, so do not forget about staying professional from the moment you enter the courtroom. Objectivity. In terms of language, be aware of sentences like I think or I believe. There is nothing that should be said to the judge or submitted to the judge which comes from your own belief or your own opinion or your subjective view of the case. Everything you say should be backed up with facts and law. So sentences like I think or I believe should be banned. That will weaken your case, and it is clear that sentences like I think and I believe will make you sound less confident. Use asserting sentences like I submit or well, I submit is very good. I can't think about anything else. What you can say also is, for example, if you are the defendant in a criminal proceedings, you can say it is the prosecution's opinion that, in order to refer to their point, but do not say it is my opinion that. Okay. But it's still better to say it is the prosecution's submission that. Alright. So that's about objectivity. And finally, clarity and precision. That's language related. It's easier to understand someone who uses active voice and short sentences. So do not try to complicate your submissions or to sound more lawyery by using long sentences and complex vocabulary. Remember that the SRA is advocating for law to be understandable by everyone. So imagine you are in a courtroom with the public. They should also be able to understand you. So do not overcomplicate your arguments. Use simple yet effective active voice sentences which are short, ideally. If you see that one of your sentences is too long, then break it up into several shorter sentences. The second criteria is using a clear and logical structure. And that is the very reason why we have already analyzed the 9-step submission structure that you should religiously follow for any of your court application. Do not miss them. Try to remember them by heart whenever you're commuting or showering or whatever. Just repeat them in your head so that on the exam day it becomes natural as saying your name. Okay. The second point, to sound logical and to appear confident as well, is to use your voice and tone. Do not underestimate the power of using your tone in order to emphasize a transition, a legal argument, or whatever. For example, once you're done with your legal argument or limb 1 of your legal test, you say, Judge, I will now turn to my second submission. See, that is not how I speak on a daily basis, but I do use my tone to mark the fact that now something is happening, there is a transition, so I just want to draw your attention, Judge. Alright, signposts is very important because the judge does not have any document about your submissions before their eyes. They do not know what you are going to talk about. It is all going to be a surprise unless you make it clear, unless you provide them with a clear plan, with a clear summary, with clear signposts. So that's a big point for you, And that will make you look confident because you are confident in your argument, you know where you're going, you're taking the rein here. So do not forget to signpost and to cross-reference. Again, I already mentioned it, but cross-referencing is very important. You're not going to get full marks for your legal arguments or for providing all relevant facts if you do not cross-reference. Alright, so now we are going to talk about one of what I believe is the most important point in advocacy, which is presenting a persuasive argument. You might think that being persuasive entirely relies on how confident you look, how you speak, how you conduct yourself in a courtroom. Well, not entirely, but at least mainly. A persuasive argument is one that flows logically from one point to another. And again, signposting and introducing your submission's order to the judge will make your pleadings more persuasive. So, what am I hiding behind me? In order to make a persuasive argument, there is something called syllogism, as we've already mentioned earlier. Syllogism is a method of deductive reasoning that is used by many fields in the world, in the scientific world, the political world. So, what is it exactly? Syllogism says that if you want to make a point in a logical manner, if you want to persuade people to believe you, you must follow a simple rule. You must first start with a major, continue with a minor, and then conclude by drawing the relevant conclusion. Applied to the legal context, the major will always be the legal test. For instance, all contracts signed under duress are voidable. The minor will always be the specific facts. The contract between client A and business B was signed under duress. And your conclusion is simply applying the major to the minor, namely applying the test to the facts. For instance, therefore, the contract between client A and business B is voidable. Okay, so that's an established way to make a point, and that will make you look confident because it's very organized, it flows naturally, and it will impress the judge that you always follow these steps when making a legal argument. Do not switch the order, right? Do not start with conclusion, do not skip the legal test because the judge will know when you will conclude anyway. No, you should state the legal test, state the specific facts, and then draw the logical conclusion from applying the test to the facts each time you make a legal point. So how do you do so in practice? For the major premise, as I've mentioned, you should always signpost. You could say, Your Honor, the governing legal principle is, and then you give your legal rule. And once you're done giving your legal rule, you expressly transition by saying, turning now to the specific facts of the case, and then you give the case and you do not forget to cross-reference. And then you take a pause so that the judge can absorb all the facts that you have given to him or her. And then you conclude and you say, therefore, applying the legal principle to these facts, it is clear that. And now you have provided the judge with a persuasive legal argument because you backed up your legal rule with evidence and drawn the logical conclusion from it. There's nothing the judge can say. Well, the judge could say something, but at least it's very logical and persuasive if you follow these steps correctly. Okay, so the fourth criteria is about how you interact with the court, how you engage with the judge. This must be in a proper way. It starts from the moment you enter the room, the moment you addressed the judge, until you conclude and leave the room. So the interaction is the whole experience. So first of all, and I might repeat myself here, but interacting with the judge starts from the moment you address them. So be careful about addressing them properly by either saying judge or your honor, depending on the court and the type of judge, district or circuit. Alright, the first point I want to mention is the speaking pace. When stressed, many students will either speak too slowly or speak too fast. So practice speaking at a steady pace is very important, because 15 minutes is kind of long for anyone to follow exactly what you're saying from the very beginning to the end. And the judge is just a human being. So if you speak for 15 minutes, mention complex legal ideas and facts, and you do not take any break, or you do so by speaking very fast, it is very likely that the judge will not be convinced, that they will feel lost, and they will not enjoy the overall experience. So pay close attention to your speaking pace. And sometimes when you're stressed, you might realize that you are speaking too fast. And the moment you realize, from that very moment, just take a second to tell yourself, okay, I'm speaking too fast, I know it. I'm just gonna pause for a second, and then continue my submissions slightly slower. Right? This is something you can do, and it's not gonna look awkward or weird. Just do it. It's better to correct yourself rather than continuing, because that's how you started. Alright, the second point is strategic pauses. Use pauses as punctuation during your submissions. Once you feel like you have provided a very good point, like you've provided the exact evidence you needed to back up your argument, pause. Pause and let the judge absorb what you just said. This is going to help you appear more confident and make your submissions more powerful. So don't overuse it, but you can pause from time to time when you want to highlight what you're saying, a point you made. The third tip is to use question framing. So instead of just stating facts, stating rules, stating conclusions, you could frame your argument into question. For example, you are in a plea in mitigation, your client, the defendant, has done an offense that is obviously wrong because they are going to be sentenced, but they had a very good reason and they tried their best. Instead of just listing everything they did that is honorable, you could say something in the lines of, what more could the defendant have done? It is a little bold. It sounds a little bold, but this is not going to penalize you. On the contrary, this is going to make the judge think with you instead of simply listening to you. And that's important. So sometimes, not all the time, do not overuse it, but once or twice, you can take one or two details that you find very relevant for your case and frame them into question to make the judge participate into your reasoning. Right, so that's my tips for your submissions, and here you are, you've made your submissions, you have concluded, and now the judge is asking you some further questions about the facts. Do not panic. It is actually a good sign because it means they did pay attention to your arguments. These questions are not here to trick you. Okay? These are opportunities for you to go from average to good or good to excellent. So take it as a chance and take a moment to think. You don't have to provide an answer right away. You can repeat the question so that it gives you a little bit more time to think about it, to compose yourself, and then try to answer to the question. And even if the answer is wrong, answer with confidence, because you might gain some points for skills even if you do not have them for law. But let's imagine you are in a situation where the judge asked you a question and you really do not know how to answer the question. Do not panic. Do not lower your head. Do not feel distressed. No. Just learn another courtroom sentence that is provided in the guide, which will help you escape from this situation, and which is something in the lines of, Judge, I might need to take further instructions from my client on this matter. I will be reverting to the court promptly. And that's it. You just let the judge know that you are going to take further instructions from your client that you cannot answer yet because you need the instruction. So that's going to help you escape from situations where you do not know what to say. Okay. Interacting with the judge is also through eye contact. And you might say that it's difficult to have eye contact when you have notes to read throughout your submissions. During the 45 minutes you will get to prepare for your submissions, you will write down a lot and you will need to read it out. So how do you maintain eye contact while reading your notes? There is a very easy trick for that. The mistake that students do when reading their note is that they lower their head too much. They hold their notes very close to their chest, and so your head is always down like this. What you should do instead is hold your notes a little further away from you at a reasonable distance so that your head is up, but you can still see your notes. And in that way, you will engage with the judge, you will have eye contact. It will be easier for you to go from your notes to the judge, to your notes. So that's an easy thing to do in order to keep the judge engaged, because there is nothing more boring than watching someone reading their notes. Although the judges knows that you are just an SQE2 candidate, so you're not a lawyer with 10 years experience and that's your first attempt, they know all of this, but it shows confidence to have your heads up. Your heads up, your shoulders up, your position matters. Even if you do not feel confident, you can still appear confident. And it's normal not to feel confidence. It's a very important exam that you've been preparing for years. There's a lot of pressure, but just pretend you are. Fake it until you make it. Just your position, your head, your shoulders, your notes in front of you, not your head down. Avoid having your heads looking at the floor. Right. That's an easy way to impress the judge, because I am betting that the judge or the assessor will be evaluating students looking at the floor all day long. So having one student with the head up looking at the judge might make a big difference for the judge. You might make an impression here. All right. So 5, including all key relevant facts. Well, with a time constraint of only 45 minutes to discover and analyze, study a case of several pages, is quite difficult to grasp all the facts of the case. And that's understandable. And I don't think anyone is expecting you to know the whole case and all the details by heart. But you should be able to highlight the crucial facts. And one little trick here is to highlight as many dates, times, deadlines, names, costs, numbers as you can. Highlight them so that you can refer to them, and that will make your case, your submissions, client focused, because you did not just provided overall facts, you gave details. So crucial facts, highlight crucial facts, and highlight details like dates, times, deadlines, names, cost, numbers, because that will make a difference. That will give the impression that you do know the case, as if you have been studying it for 24 hours. Again, aim to quote at least one sentence per limb of your legal test. It's very important that you refer the court to the bundle of documents. You draw the court's attention to actual evidence and not paraphrase everything. You must, for each limb of your legal test, at least one, refer the court effectively by saying, may I refer the court to page 9 of Mr. Smith's witness statement dated April 9, 2023. I quote, Right. Next we have applying the law correctly. Well, before that, I just want to make a small comment. Confidence comes with a good structure. Confidence comes with knowing exactly what we are going to do, which steps we are going to take, what comes after what. But it's okay and it's normal to feel nervous as well. So how do you handle stress? How do you manage it on the exam day? What if you were always confident when you were practicing, but on the exam day, because of the pressure, because of how important this day is to you, you feel stress and you do not feel confident? Well, I would say, first of all, remember your purpose. You are a solicitor. On that day, imagine you're a solicitor. You've received a real client case. That client is relying on you, is trusting you. They need you to defend their interest. So imagine it's not fake. Imagine it's real. You have a client and then they're relying on you. You have a purpose to help your client. I believe many of you decided to do law because they wanted to help people, they wanted to defend people, they wanted to argue maybe, and make good points, win cases. So now is your time. Now is your time to prove that you can defend a client. So remember your purpose. We tend to forget when we are nervous our purpose, why we are here. We tend to feel overwhelmed by the pressure. So that is a good way to manage stress. Just remember your purpose. You are here for a reason. You have knowledge and you can defend a client because you know the law and you know how to make a good legal point. You have a good structure in mind. You know syllogism. You know how to make a convincing case. Not everybody knows that. You do. So you are in a good position to help your student. To help your client. Okay. But imagine you're still nervous. Or imagine you're making your submissions and somehow at some point you just lost your train of thought and you're telling yourself, oh my god, the judge realized I am not speaking for the last 10 seconds. It's very awkward. What are they thinking about me? It's not a good impression. And then this roller coaster. So what you should do in this type of situation, when you feel like you lost your train of thought, you are hesitating, do not show it to the judge. Instead, what you should do is simply let the judge know. You say, Judge, I would need a minute to find the witness statements from the bundle of documents. That will give you a second to compose yourself. Or you could just say, Judge, I would need a minute to gather my thought on this particular issue or facts or whatever. So just let the judge know that you are now taking a minute to think. They're not going to penalize you for that because that's actually clever. That's my tips for handling stress on the exam day. Now, the last two criteria are about applying the law properly, applying the law to your client case. But there's no secrets. First, to apply the law correctly, you must know the law. You must know what kind of court application it is. You must know the legal test for that court application. You must know how a contract is formed, for example, if it's a contract or related issue. So that's no secret. But you also, in advocacy, need to use judgment with integrity. So if there is any ethical issue, do not try to hide it. One important point about applying the law in advocacy is reaching reasonable conclusions. So do not downplay the facts if they are serious, even if you are trying to defend your client, especially true for criminal proceedings. If your client has a bad criminal record, if they seriously harmed the victim, do not downplay the significance of their action. This is going to undermine your presentation. The judge might think that you are actually biased if you believe that a concussion or a broken arm is not that serious. They're not gonna believe in your credibility. The judge is going to tell themselves that you are not that objective, that you're quite subjective, that you're trying to defend your client no matter what. So you should reach reasonable conclusions. It's very important. Right, so we are now done with the criteria set by the SRA for advocacy. Again, remember, this is not a competition. We are not here to see who amongst the SQE2 students is best at defending their client or their case. We are here to see if you're capable of simply following the submission structure and making legal arguments with a logical reasoning. That's it. The SRN knows that you've never done that before, and you will have plenty of time to improve. So just try to have fun, to use the guidelines, use the structure, and show you're capable of defending your client interest as best as you can, following a specific structure. Now, confidence comes from knowing. The more you know about a specific situation, about what to expect, how to react, the more confident you are. So I'm now going to give you a few details about what to expect on the exam day. Exactly what will happen on that day, if you don't already know it. So you will go to your exam center and you will be divided into approximately 10 candidates group. So you will be divided into groups of 10 candidates, and each group will be taken to a preparation room. Once you are in your preparation room, you will be asked to remain seated, and you will have before you a case study. Once the 45 minutes starts, you will have 45 minutes. You can start reading your case study. Everybody is going to have exactly 45 minutes. You will be given a few highlighters, pen, paper, and a clock in front of you in order to effectively manage your time. 45 minutes is quite short for an advocacy case study of several pages, and for you to effectively prepare for the oral exam. So I would suggest that you use the acronym that is provided in the advocacy guide in order to remember the 9 steps by heart, and you put the letters of each letter of the acronym on the margin of your sheet of paper, so that you are sure you are not missing any step. Right. Later on during this webinar, we are going to learn a few courtroom sentences in order to introduce yourself, introduce your party, help you summarize your facts, ask the judge whether or not they have the bundle of documents, etc., etc. So all the parts, the steps in court application that are never changing, that are always the same no matter of the nature of your application, such as introducing yourself, introducing your parties. This you must know by heart, and you should not lose any time writing it down on the exam day, because you are short in time. This you should know by heart, and you should just write on your sheet of paper introduction, addressing the court, or just A for addressing the court, for example. So you know how to address the court beforehand. You should not take some time to think about, okay, so how should I address the court? How should I introduce myself or introduce my party? This should be automatic. You should not waste any time writing it down during these 45 minutes. All you should focus on is analyzing the case, getting used to the facts. You should write down the legal test, and you should pinpoint or write down the facts, an overview of the facts, specific facts on your sheet of paper. But you should not waste any time writing down things that you can just learn by heart. So focus on the core of your pleadings, things that you cannot anticipate before the exam day. Okay, so now the 45 minutes are over. The vigilant will be taking you from will be taking you from the preparation room to the assessment room. All other 10 candidates of your group will be waiting in front of a door until you will be asked to knock at the door. Once you are told to knock at the door, you knock and you enter, and from the moment you enter, you are effectively in a courtroom, and you should act accordingly as a solicitor. You cannot ask any question to the judge that will impersonate the role of a judge throughout your submission. So there's no, oh, is this the right room, or should I start now? No, you enter, you are a solicitor in a courtroom. Okay, so then you have 15 minutes to make your submission, and you should allow 1 or 2 minutes for the judge to ask any questions if needed. So be careful about not taking too long when speaking, and not being too short either, because the case scenario is meant to last 10 to 15 minutes. 15 minutes. So if you are only pleading for 8 minutes, well, you might be missing a few points. Right, so here you are, you have pleaded, you have made your submissions, you have concluded, and you can now leave the assessment room. And that's how your oral exam ends. What else can I say about what happens on the exam day? Let me think. Yeah, that's all I can think about. Okay, so next, advocacy practice. A few sentences you can use in any court application. That's very useful. Not a lot of candidates are used to interacting with a judge or in a courtroom, so there are some specific jargon, some specific etiquette you might need to follow. Well, it is advisable to know, and you will make a good impression if you know how to speak to a judge properly. it will give the impression to the judge that you might actually already have experience in making submissions before a court, and that is going to help have a better grade. Okay, so we did mention that every one of your submissions should have exactly 9 steps. I'm going to give you sentences for each one of these steps. The first one, if you remember, is addressing the judge. That's easy. You address the judge by saying, "Judge" or "Your Honor." That's as simple as that. Second, you should introduce yourself. And third, you should introduce your party. A way of doing so would be, for example, by saying, "My name is Ishana Mohammed and I appear on behalf of the defendant, Mr. Smith, who has been charged for causing grievous bodily harm contrary to section, I can't remember exactly, of the Offence Against the Persons Act." Right. So that's the first 3 steps. Now, step 4, you state the nature of your application. You can do so by saying, "This is an application for the judgment entered in default dated 7 March 2021 under CPR Part So to be set aside." In criminal proceedings, you could say, "Mr. Smith was charged for causing grievous bodily harm contrary to section number of Offence Against the Persons Act. This is an application under section 76 of PACE 1984 to exclude a confession. I will seek to persuade the court that such confession should be excluded on the ground that it was improperly obtained by the prosecution." So that's step 4. See how I sometimes use my tone to make my point a little more stronger, powerful. All right, step 5, the bundle of documents. Judge, you should have before you a bundle of documents with copies of so and so, which I will be referring to throughout my submissions. The judge will answer, "I do, thank you," to which you will reply, "I am most grateful," or "I am grateful." Step 6, the summary of the facts. If it pleases the court, I will now give a brief summary of the facts before making my detailed submissions. And then you give your facts. If you are in a civil claim, for example, you could say, "The claim is for the sum of £10,000 being the price of this and this item sold and delivered by the claimant to the defendant. The claimant claims damage arising out of an accident when she was allegedly suffered a fracture, for example." So this is sentences you will find in the guide that you can download on the FQPS Academy, and I advise you to learn them by heart because you will feel confident knowing exactly how to address the court, and the court will find you confident in turn. Alright, so step 7, you should clearly state the legal issue raised. The legal question raised in this matter is whether, and then you precise. The question is, and then you provide the legal issue. Now step 8, the core of your pleadings. You must provide your legal points. And you start by giving the legal rule. Judge, as I'm sure you're aware, and as a general rule, in criminal proceedings, hearsay evidence is not admissible. However, confessions are an exception to the hearsay rule, Section 76A of PACE states that in any proceedings, a confession made by an accused person may be given in evidence against him, insofar as it is not excluded by the court. Judge, it is my submission that the confession made by the defendant should in fact be excluded. And that's how you state your legal rule. And you cross-reference during the course of your pleadings by drawing the court's attention to specific pages of your bundle of documents by saying, for example, may I remind the court of the circumstances and refer the court to page 9 of the bundle, and I quote. Or if I could draw the court's attention to page 9 of the witness statement, page 9 of the bundle of documents, I quote, and then you quote. Step 9, you conclude. For this reason, therefore, the claimant cannot show so and so. The defendant submits that both limbs of the test have been met. It is my submission that the court should therefore set aside the default judgment made on April 9, 2023. And then the second part of your conclusion, unless I can assist the court further, this concludes my submissions. And now you are done with your submissions, but the judge might ask you a few questions. And if you do not know how to answer, you can say, Judge, I will need to take further instructions from my client on this matter, and I will promptly provide the court with an update. Or, Your Honor, I need to consult my client to provide a precise response. I will revert to the court shortly. Or, and finally, Your Honor, I must defer answering until I have confirmed the specific with my client. I assure the court I will update you promptly. And that's it for the sentences I believe you should learn. It will help you honestly feel more confident, because you will know exactly how to communicate with the court, which is not an easy matter when you have never pleaded in your life. So take some time to read them out, learn them, and practice saying these sentences out loud so that they become natural to you before the exam day. Now, that concludes my webinar, and I hope you found it useful. I would really like to know how you did on your SQE2 advocacy oral exam. I love hearing from candidates, and I would like to help you as much as I can. So know that you can book a free SQE2 one-to-one support consultation with myself by scanning this QR code. I'll take some time to understand your specific circumstances and see if I can advise you in order to perform better on the exam day. This webinar was organized by FQPS Academy, so thank you to FQPS Academy. Do not hesitate to leave a review if you enjoyed it, and go have a look at the website. Thank you very much. Good luck.